Absolutely, there's loads of time. Apologies have been received from Deputy James Lawless, who's attending a joint policing event on community policing. I'd ask members and witnesses to turn off their mobile phones or to switch them to flight mode, please, as they interfere with the sound system and they make it difficult for the reporters to cover the meeting, and also television and web streaming is adversely affected, so please put them on airplane mode. The purpose of our meeting today is to have an engagement with a number of stakeholders who are very welcome as part of the committee's scrutiny on the general scheme of the Inspection of Places of Detention Bill 2022. And I would like to welcome to our meeting the following witnesses: Mr. Mark Kelly, Chief Inspector of the Office of Inspector of Prisons; Dr. Ciara O'Connell, Senior Inspector, Office of the Inspector of Prisons; Dr. Pauline Conroy and Ms. Nuala Ryan from the Prison Visiting Committees; Ms. Orla Keane, who's the General Counsel for the Mental Health Commission; Dr. Joe Garrahy of Maynooth University; Ms. Saoirse Brady and Ms. Molly Joyce of the Irish Penal Reform Trust; and Mr. Liam Herrick and Mr. Sean Beattie of the Irish Council of Civil Liberties. You're very welcome, and indeed our representatives from the Department of Justice, Ms. Lisa Doherty and Mr. David Hogan. You're also very welcome as observers and participants. So before I invite witnesses to deliver their opening statements, I'd like to advise you of the following in relation to parliamentary privilege. Witnesses and members are reminded of the long-standing parliamentary practice that you should not criticise or make charges against any person or entity by name or in such a way as to make him, her or it identifiable, or otherwise engage in speech that might be regarded as damaging to the good name of the person or entity. Therefore, if your statements are potentially defamatory in relation to an identifiable person or entity, you will be directed to discontinue your remarks, and it's imperative that you comply with any such direction. Okay, so I will invite each organisation to make an opening statement to a maximum of 3 minutes, please. Once all of the opening statements have been made, I will then call on the members of the committee in the order that they indicate to me to put their questions. The way we do it is we have a rota system which provides that each member has an initial 7 minutes, and that's for questions and answers. So members are always very succinct in their questioning because of that. When all of the members have indicated that their initial engagement is finished and time permitting, we'll do a second round, which would be 3 minutes for questions and answers. So the duration, obviously, of this meeting is limited, and therefore our times are strictly adhered to, so I would ask people to be focused on their contributions. So I will now call on each of the organisations to deliver your opening statements as follows. Mr. Kelly from the Office of Inspector of Prisons, followed by Dr. Conroy, Ms. Keane, Ms. Brady, Mr. Herrick, and then Dr. Garrahy. So, Mr. Kelly, you have 3 minutes, please.
Well, thank you very much, Oscar senators, deputies, for the opportunity to share with you the views of the Office of the Inspector of Prisons on the general scheme of the Inspection of Places of Detention Bill. I'm the Chief Inspector of Prisons, and I'm accompanied on my left by Dr. Ciara O'Connell, who is a Senior Inspector. And once enacted, the provisions in this general scheme will pave the way for Ireland to ratify the optional protocol to the UN Convention Against Torture, or OPCAT, and to designate national preventive mechanisms to monitor conditions of detention. And we welcome the very clear legislative intent to transform our office into an inspectorate of places of detention and to designate it as the national preventive mechanism for the criminal justice sector, which would mean that we would have responsibility for monitoring prisons, but also Garda Síochána stations and other places of detention. And I'd like to emphasise at the very outset that in future, all of our inspection activity will be carried out in our MPM capacity. And the approach that we have taken in our written submission to you is to benchmark the proposals in the general scheme against the internationally recognised requirements of the OPCAT. And there's much to be welcomed in the general scheme. Nevertheless, we have shared with you our reservations about a number of the current heads that do not seem to respect the cardinal principle that bodies that are designated as national preventive mechanisms must have functional independence from government departments and a full range of appropriate powers. And in our full submission, we emphasise 3 key areas where we consider that the general scheme may require amendment. Firstly, the guarantees of functional independence of the inspectorate and other national preventive mechanisms, which in our view are deficient. Secondly, the proposed functions of the inspectorate. And thirdly, we think that there are certain supplementary provisions that should be included in the legislation, but which are not currently to be found in it. And I'll be very happy indeed, as will my colleague Dr. O'Connell, to go into further detail on all of these matters in response to questions from committee members. Thank you.
Thank you very much, Mr. Kelly. Now, Dr. Conroy, you have 3 minutes, please.
The publication of this bill is a very welcome development and starts to consolidate some of the human rights to which people deprived of their liberty are entitled. And visiting committees are a particular kind of structure. We monitor, not inspect, we monitor the activities of prisons and speak directly to the prisoners. And we're in and out of the prisons constantly, daily, could be weekly, fortnightly, monthly. And in these interactions with the prisoners, we try to be impartial, independent, and we also try to listen very carefully to them, because the listening is possibly, we are the only independent people that a prisoner will meet on the landing of their prison or in their cell. So ours is a very humane, but nevertheless a rights-based approach. And we represent the views and voices of prisoners and the conditions of the prison estate. And that's why we're concerned about some of the proposals that would have visiting committees drop into a prison once every 3 months. Well, that wouldn't reveal very much once a month for 2 or 3 hours, or 3 months. You wouldn't be able to observe how frequently mattresses are being placed on the floor for prisoners to sleep on. You wouldn't be able to observe if prisoners are showing signs of enduring mental illness, which is visible when you attempt to talk to them. So our submission addresses primarily section head 13, which goes into some detail concerning visiting committees and proposes an entirely new structure to that which we have at the moment. Now, prison visiting committees have been there since almost 100 years now, so it's quite obvious that they do need reform, but we're not sure that you should throw out the baby with the bathwater. There are elements of visiting committees' work which are useful and valuable and appreciated by the governors of prisons. Sometimes governors who are actually not mentioned at all in this bill. Governors have, as managers and under law, have a huge role to play, but we don't see them here. So a visiting committee can provide independent and systematic observations of the prison system, and in particular, unexpected consequences of changes in rules or policy and changes in the composition of the prison population. For example, whether more and more of the prisoners are on remand rather than sentenced. And at the moment, about 4 out of 10 are on remand. So this poses big questions as to whether opportunities for rehabilitation are going to be made available, because these prisoners don't know they're going to be sentenced, or how, or if. So this disrupts, but it's an unexpected consequence for the prisons of the judicial system.
Thank you, Dr. Conroy. That's the 3 minutes, so I'll move on if that's okay.
I'll answer questions.
No, thank you very much. Thank you. I'll move on now to Ms. Keane from the Mental Health Commission, please.
Thank you very much. Firstly, just to extend the apologies of our Chief Executive due to a very last-minute unexpected issue. He was not able to attend. The Commission welcomes the opportunity to be here today. As you may be aware, the Commission is the regulator for mental health services, so it carries out inspections in relation to mental health services, and it also organises tribunals to independently review those who are involuntarily detained. In relation to the inspection, it's important to note that the inspector has the right to visit any resident at any time as part of inspection, but also has an obligation to visit any resident that requests her to do so. So that is currently in our legislation, and the visitor and the inspector does so. We thought by way of assistance to you that detention under the Mental Health Acts, we've included a paragraph there by way of explanation of how many people are detained. So, for example, in 2021, 3,759 involuntary detention orders were made, and each and every single one of those are reviewed within 21 days. They're reviewed by an independent body made up of 3 people, a chair, a consultant psychiatrist, and what is referred to in the legislation as a lay member. And this is a key part in the 2001 legislation of vindicating the rights of persons who are involuntarily detained. So the Commission has limited its submission in relation to the scheme to Part 3. It welcomes the intent. It notes that the CBT in its report in 2019 stressed the fact that legislation hadn't been progressed in relation to MPMs, and it's a good thing that we're here today and that has progressed. The Commission also welcomes the proposal for the National Preventative Organisations and also the proposal that IRAC, with its all of its resources and its skills, would be the coordinating body. The Commission has noted that there are some gaps in the legislation, and I note that we've had access to at least one other party's submissions, and we note that they have identified similar gaps. But we know that this is the early stage, and perhaps some of those gaps will be filled during the course of the drafting. Thank you.
Thank you very much. Thank you very much, Ms. Keane. And now we move on to the Irish Penal Reform Trust and Ms. Brady. Thank you.
The invitation to speak here today on this really important and long overdue piece of legislation. I suppose the Irish Penal Reform Trust has been advocating for the ratification of the optional protocol to the Convention Against Torture, or OPCAT, for many years now. We welcome this bill as a significant step forward in making ratification a reality, and we urge the committee to give the bill its full attention over the coming months to ensure momentum is not lost and that the final legislation is robust in meeting international human rights standards and best practice in monitoring and inspecting places of detention. OPCAT is clear that the state must guarantee the functional independence of national preventive mechanisms as well as the independence of their personnel. The Subcommittee on the Prevention of Torture, or the SPT, details that this includes financial and operational autonomy. As it stands, IPRT is not convinced that the bill sufficiently establishes such functional, including financial and operational, independence. Concerns include the budget of the new Inspectorate of Places of Detention remaining within the remit of the Department of Justice under Head 3, rather than having its own vote, and the restrictions imposed on the Chief Inspector around questioning or expressing an opinion on the merits of government policy, which is Head 11. Resourcing is an overarching consideration in this bill. Firstly, there is a need to ensure that the new Inspectorate of Places of Detention has the resources to take on the role of MPM for prisons and Garda stations. Secondly, and separately, IRAC must be provided with additional resources to carry out the extensive additional duties assigned to it by this legislation. It's also important that the bill explicitly sets out IRAC's proposed MPM coordinating function as distinct from all its other responsibilities, and that designated MPMs, including the Inspectorate of Places of Detention, are enabled to maintain a clear distinction between any investigative functions they might hold and their inspection and monitoring functions as MPM. IPRT would also welcome clarity on whether it's intended that the prison visiting committees will be designated as an MPM, and believes further discussion is needed on the proposed role of the new Inspectorate of Places of Detention in supervising the visiting committees. Article 24 of OPCAT makes clear that ratification is not dependent on the passing of this legislation. Rather, the government could ratify OPCAT today and simply make a declaration postponing the implementation of their obligations for a maximum total of 5 years with an additional year to designate the MPM after ratification. Commitments to bring forward the current bill and move towards ratification of OPCAT have been consistently missed since 2018. While IPRT welcomes the current progress in respect of this bill, we remain of the view that the government can maintain the necessary impetus and make significant progress by ratifying OPCAT with immediate effect. International guidance describes the important role that civil society can play in both designating and feeding into the work of MPMs, and a good example of this is the Australian OPCAT network, and we'd be happy to answer more questions on that specific issue. Given the importance of civil society engagement, IPRT urges committee members to recommend the establishment of a clear formal role for civil society in the designation and operation of MPMs in the proposed legislation. And thanks again for the invitation to present here today, and we look forward to further discussion on any of the aspects of our submission that we've covered in our opening statement or in our submission.
Thank you very much. Thank you very much, Ms. Brady. I'm going to move to Mr. Herrick now, actually, is my order. Mr. Herrick, please.
Thank you, Caherlic, and thank you and the committee for the opportunity to share our observations today. ICCL has long called for a proper independent inspection mechanism for all places where people are deprived of their liberty in the state. When deprived of their liberty, people are more vulnerable to abuse, ill-treatment and torture, and proper safeguards must be in place. Ireland ratified the the Convention Against Torture in 2000 and signed the optional protocol in 2007. So we're 15 years waiting for ratification of OPCAT, despite it being promised by successive governments. And this, we believe, is finally now an opportunity to put in place a proper independent inspection system in Ireland, which will comply with the highest international standards. The bill proposes a framework for a national preventative mechanism, or NPM, to prevent torture and ill treatment, which is most welcome. However, we do have some concerns about the general scheme as presented when compared to the standards of OPCAT, and we're very eager that at this stage of the legislative process we can work together with government to secure the highest possible outcome. The first issue for us is, as has been said by our colleagues in the Penal Reform Trust, that the government has decided against ratifying the optional protocol before the bill becomes law. And while this does reflect general government policy regarding international treaties, this treaty is significantly different because it specifically provides for engagement with the expert international body, the Subcommittee on Torture, or the SPT, in the process of developing the national legislation. We would also urge government to expand the NPM and the breadth of the proposed legislation to cover all places where people are deprived of their liberty in Ireland. We must include social and care settings, such as psychiatric hospitals, which there's very little detail in relation to the bill, nursing homes and direct provision centres, and we're happy to answer questions with specifically some provisions on those non-criminal justice areas of detention. Of crucial importance, as has been outlined by the Inspector of Prisons and others, is the principle of functional independence of the NPM. The UN SPT has set out standards in this regard, and there are a number of areas in which the bill, as the scheme is currently drafted, currently falls short. In particular, we recommend that the NPM is independent from government departments and accountable only or primarily to the Oireachtas. And we identify the specific flaw in the proposals in that it provides for a prohibition on the new inspector issuing observations on government policy or legislation. A gap in Ireland's inspection regime that is of particular interest to us is the lack of any statutory-based independent inspection of police custody to date. It is proposed in the bill to address this deficit. However, we think it's essential that this bill is coordinated and aligned with the proposals in the draft Policing, Security and Community Safety Bill. And finally, we encourage government to enshrine collaboration with civil society in the text of the bill itself. The SPT has set out very clear guidelines for how civil society can play a role both in the design of the NPM and in the ultimate functioning of the NPM. My colleague Sean Beattie and I are very happy to take questions on any of these issues.
Thank you very much, Mr. Herrick. Now, Dr. Garrity, please.
Thank you. I thank the committee for the invitation to contribute to the discussion on the draft bill of places of detention and facilitation in the circumstances. I'm a professor of criminology at Maynooth University School of Law and Criminology. I'm a specialist in penology, including national and international frameworks, policies, prison systems and prison literature. I hold a PhD in law from the law school in UCD in criminology. My research generally focuses on diverse areas such as prison officers' occupational cultures, cocooning in prison, and minority ethnic and foreign national prisoners in Ireland. My collaborative and co-produced work has established relationships with colleagues here, such as the Irish Penal Reform Trust, the Irish Council for Prisoner Overseas, the Pathways Centre, the Irish Prison Service, Probation Service, and His Majesty's Prisons and Probation Service in England and Wales. I welcome the production of the draft bill as a key step towards the ratification of the optional protocol and its associated progression in prison oversight in Ireland. The development and consistent review of an effective system of prison oversight should not be an aspiration. Rather, it should be the minimum standard required by the Irish state, and the bill presents an opportunity that must be grasped to ensure this. There are three key areas that I'll briefly mention, but I'm happy to discuss the respective submissions of Dr. Marder, my colleague, and myself afterwards. The three key areas are the independence of the proposed Inspector of Places of Detention, the IPD, the clarity of roles, obligations and expertise of the proposed IPD, the implications and opportunities for replacing or reforming prison visiting committees, PVCs. The ratification of OPCAT is imperative. But under Article 18 of the protocol, oversight bodies or national preventative mechanisms, NPMs, must have, in perception and practice, full independence from prison services, management and staff, and government officials and departments. This independence must include, but is not limited to, financial and resourcing, publication capacities, staffing and the commission of external expertise. NPMs must be precisely that, preventative rather than reactionary. The pernicious effect of imprisonment are well versed in the literature, and imposing sanctions must be proportionate while avoiding known collateral harms. I acknowledge that the bill remains in draft form, and further work will provide additional details and clarifications on several matters. However, the bill will benefit greatly from clarity in many areas around language, structure and content on topics including IPD powers, obligations, expertise and resourcing. Questions remain about these issues, and opportunities afforded by the spirit of the proposed bill would be best served by careful evidence-based decisions in these areas. The draft bill will have major implications for the reform or replacement of PVCs. While overdue, fundamental questions must be addressed directly about the aims, role and structures of PVCs. To maximise the utility and effectiveness of any future form of PVC, due regard must be given to issues such as role, clarity and powers, the appointment of chairs and members, term limits, diversity and representation, training and expertise, publication, visibility and engagement with people in custody. I appreciate that these comments are necessarily brief, but I am happy to elaborate further upon request and look forward to the forthcoming discussion.
Thank you very much, Dr. Gary, and thank you very much to all our witnesses. Could I just clarify something before we begin questions with the department? Is the department already engaged with the subcommittee on torture by any chance? Okay, that's helpful. We'll come back to it, though. I just wanted to check just in relation to the ICCL question. Okay, Senator McDill is starting for us this afternoon.
Thank you,
Thank you.
Thank you to all our witnesses. Can I say a few things? First of all, as somebody who had experience of ministerial responsibility for the prison service, I'm convinced of a number of things. I'm convinced that this legislation is necessary. I'm convinced that the prison visiting committees need to be strengthened and reformed. I'm also convinced that the Chief Inspector should be somebody who is made by statute independent, and I don't believe that it's necessary in that context to impose on the Chief Inspector the obligation imposed by legislation on senior civil servants testifying before Oireachtas committees that they shouldn't express an opinion on government policy. I think that the position would be enhanced by the removal of that particular aspect. Can I also say that when I was Minister for Justice, I remember finding among the papers from my predecessors, and I'll be charitable, I won't name any names, one from a TD in the south of the country asking that a student member of his party should be appointed to a prison visiting committee as far north as possible. And I think there was an exclamation mark beside it, so I think there was a slight element of jocularity about it. But it underlined that prison visiting committees were at that time regarded as a kind of a reward for party activists and supporters who could claim expenses. And I think that the proposal here as to their appointment, because they do very valuable work, is very, very welcome indeed. I want to say as well that as far as I'm concerned, it's all very well to talk about rights-based approaches to prisoners, but I mean, our present prison infrastructure, and I'm dealing now with prisons, is so deficient that prisoner-on-prisoner violence is a really serious deprivation of human rights. And that requires not simply the appointment of an inspector who will be able to do nothing to stop blades being carried in prison and retribution being meted out to prisoners in individual cases, but we need more infrastructure. We need to build Thornton Hall. We need to have a proper prison Mountjoy, good and all as the reforms that recent governors have brought into how it is governed since the appalling situation that was revealed in the Gary Douch report. good and all as those improvements have been, it needs to be closed and it needs to be replaced. And I'm just saying that, you know, we can't have this complacent approach to prisons, that the infrastructure is fine, and here we're going to look after people's rights and civil liberties and all the rest of it, if we don't address what is staring us in the face, which is that prisoners are vulnerable to each other. They're vulnerable to a whole drugs culture which little or enough is done to address, and the circumstances which are there according to the Constitution and the law, which is to provide for rehabilitation, they are, because of the lack of infrastructure, hugely compromised. So I want to say that here we must build prisons. I know there are people who think that building prisons is a waste of time, but building a new and proper prison, at least one and maybe more, to guarantee the rights of prisoners physically and to give them safety from each other and to allow for proper segregation of prisoners is, in my view, a human rights issue which cannot be postponed. Can I just simply say this, that if we don't allow the Chief Inspector of Prison to express views about government policy when brought in before a committee of Oireachtas, effectively they are neutered as guarantors of people. And it won't affect the Department of Justice that the Inspector of Prisons feels free to do so. I remember the late Mr. Justice Dermot Kinlan had no difficulty when he was made Inspector of Prisons taking lumps out of me as Minister, and it was good that he felt free to do that. And I believe that it's hugely important that independence of the Inspectorate is guaranteed by the legislation as it comes forward. So I'm not really asking questions. If anyone wants to agree or disagree with me, please do. But those are my views on the matter.
Thank you, Senator. Is there anybody who'd like to give it? Thank you.
I welcome your comments around independence, Senator McDougall. But I would have to say, in terms of prison infrastructure, I'd have to disagree in Thornton Hall and the building of a new prison. While I think that we do need better infrastructure, government policy now is to reduce the number of people in prison overall. And I would hope with doing that, we would end up having the space and resources, time necessary to actually make our prisons what they should be to ensure the civil liberties and human rights of people within them. You know, the policy options review and action plan that was published by the Minister for Justice Helen McEntee on the 31st of August, you know, there is a very clear direction here that people who are sentenced for minor offences for under 12 months shouldn't be in prison in the first place. And, you know, last year in 2021, 79% of all sentence committals were for 12 months or under. In 2020, it was 78%. We're seeing a trend of this happening. So if we can address those issues, I don't think that there's a need to necessarily build a whole new prison. Like we've seen recently, improvements in Limerick Prison. I think we can actually renovate and do things to the existing prisons within resources.
I agree with you on one point, and that is that short prison sentences are should rarely, if ever, happen. Rarely, if ever, happen. And the blight, especially on younger people, of having been sentenced to prison, particularly when they're drug infested, particularly when they're violent, and particularly where there's no proper system of rehabilitation, and particularly bearing in mind the figure we heard about the number of people who are there in remand. You know, I agree with you 1,000% on that. But let's be frank too. Mountjoy will never be an appropriate place to incarcerate people. I've been there on a number of occasions, and I've seen the improvements that took place in management, but it's still innately inadequate in my view. And it needs to be replaced. And there need to be playing fields, there need to be running tracks, there need to be things like that for people who are genuinely in need of rehabilitation, as well as proper facilities. It's not going to happen in Mountjoy, so we've got to cop on and accept that institution must be replaced. And the second thing is this: we have a growing population. We have now, we're going towards 5.5 million from a prison system which was serving a population of 2.8 million when I was born, or 2.9 million. We can't pretend that the number of prison spaces that we have at the moment is adequate, bearing in mind the number of life prisoners and serious sentences for sexual offences and all the rest of it that are being handed down by the courts. And I don't want a situation where a revolving door starts again for people with significant prisons. But I do want to reiterate my agreement with you that short sentences. I at one stage wanted every district judge who was about to impose a short sentence to write out in his own handwriting or her own handwriting why no other possible way of dealing with this prisoner was being contemplated, just to rebalance the matter in favour of non-incarceration. So I'm with you on that, but I'm still saying what I say: we need proper modern prisons.
Can I just say, Mr. Kelly, just very briefly, if you mind, on the public policy piece, is it?
Yes.
Just very briefly, because we're over time.
Yes, very briefly, just to thank Senator McDowell for his comments in relation to independence, to emphasise that if I couldn't comment on government policy, I literally would not be here before this committee. So it would be a retrograde step in future if that were to go through. But in relation to the more general point about the safety of prisoners, really to underline that the proportion of the prison population now which is seeking protection from others is growing exponentially in many of our prisons. So it's not just a question of building new prisons. They also have to be resourced, and the regimes have to be resourced recently. And to finish, last week I had the opportunity to spend some time in the really very impressive new prison facility in Limerick.
I haven't been to that.
You should go and see, Senator. It's very impressive. But they will not be able to deliver on their aspiration to respect the rights of the prisoners who will be held there at great expense unless it's properly resourced and the regime is properly resourced. So that's the necessary counterpart to the infrastructure.
Yep.
Okay.
Thank you.
I visited the new women's prison in Limerick recently, and it's very impressive actually as a new facility, but how it's delivered is different and important. Deputy Paddy.
I know the department are here. You're here to answer a few questions as well, I presume. Then is that the case?
Strictly speaking, it's observer status, but I'm sure the department won't
just
mind clarifying a question or two, as they already did for me.
Yeah, there seems to be across the board consensus in relation to OPCAT ratification and the need for more independence of the inspector when it is established. Having it under the Minister for Justice and all the budgets, just across the board, I think there just seems to be great concern with that. And I wonder, did the department have any comment to make in relation to that? I wonder, maybe I'll ask Mr. Kelly, is he happy, or do you think that there should be a role for inspecting Garda stations? I know that the similar body in the 6 counties does have a role to go into the PSNI police stations and inspect there. I was on at a meeting with the Criminal Law Committee of the Law Society at one stage where there was various concerns about what happens in Garda stations from the point of view of solicitors being in there, and nothing seems to have been done in relation to those concerns. So I wonder, do you have any opinion in relation to that? While I've heard what's been said about new prisons, but we had a meeting last week with the Justice Committee of the House of Commons who were over here. One of the things that came up, we have the lowest amount of judges in the EU, or is it second lowest? And that needs to be addressed. And also, they were concerned, they went to Clover Hill, and they were very concerned that there was a lot of trials taking place where the prisoner comes out of the jail and into what a solicitor in Tralee used to refer to as the fish tank to have their trial dealt with. And there are an awful lot of sentences. This is something that we heard when we visited Mountjoy earlier on in the year. The amount of short sentences, that was a concern by the prison staff, by some of the prisoners. And, you know, maybe the judges need to go there, go to Mountjoy and listen to what the prison governors have to say about the uselessness and ineffectiveness of short prison sentences, because when prisoners are released, they are back to homelessness, back to hostels, back to unemployment, and usually back to addiction. So they don't achieve anything, and they're on a sentence of 6-7 months. There's no educational facilities put in place during that time. There is also a concern. Going back, I suppose, for 20 years now, there's been a drift towards a larger number of people on remand, and there is, I think there's a statistic there, is it 40%? Since COVID, there are an awful lot more prisoners on remand in the jails, especially for the more serious offences. They are being denied bail. The other options which are explored and were explored in our meeting with the House of Commons Committee of tagging and keeping them observed without having to go into custody for longer sentences, and the average, I think, time for the serious trials to come to court is now about 2 years, and there was big concerns over that, and that is filling up the jails, and I think that should be addressed. The number of judges should be, even though there was 5, I think, was heralded as being a good achievement. There was 5 appointed recently. There needs to be way more judges appointed to cut through the backlog before we ever consider constructing more prisons. And just, was anyone like to comment on there was a report into the women's prison, which I think has not been published yet by the department or printed by the department, and led to the resignation of one of the members. And is there any sign of that report into the conditions in the women's prison being published? Not sure that I have anything else. I'd like to ask the members of the visiting committee, when you're speaking to prisoners and they give your concerns to them, and when you go to the governors with that, have you had much experience of the decision of the governor being overturned following your representations on behalf of the prisoners that you're meeting? And does anybody have a view about whatever is going to happen when under Head 13 about the new prison visiting committees? What kind of experience, qualifications should they have? What resources should they have? Should there be legal backup, or should they be paid?
Okay, so shall we start with the prison?
Might be busy.
There's a lot of questions in that. First of all, should they be paid? Are they volunteers? We're not volunteers, and the prison visiting committees are, we were appointed by the Minister, as you know, the Minister for Justice, with the eyes, ears and nose of the Minister in the prisons. So we would want to be, we're not volunteers. When we meet a prisoner and we see the prisoner regularly, and they speak to us, you know, they look for an appointment with us, they come and see us, and we walk the floors, and we're in and out of the prison all the time. We hear their complaints and we hear their concerns. A lot of the concerns could be dealt with, shall we say. But we would go to the governor with them. We would go and consult the governor, and the governor would take it on board. But I don't remember any cases where it was actually overturned. I don't remember anything like that.
What else would you like?
We would go and speak with the governor and the appropriate authorities. A lot of the stuff can be practically resolved. You know, could be to do with post, close, you know, missing stuff and appointments, wanting to get back on, you know, phone calls with families and things like that. They can be easily resolved and dealt with, and that's what the visiting committee would do and do very well. That is what makes us unique, in that we can go in and we speak to the prisoners
okay,
themselves.
So just nothing has been overturned, but do you have a view then should there be an external adjudication of any
Well, it would really depend on what
breaches
the case
prison
was.
discipline?
Yeah, if the issue is very serious and concerns the prisoner's sentence, for example, or a case that's coming up that he's worried about, we would not discuss that. We would refer him back to a solicitor if he doesn't have a solicitor.
In relation to internal prison discipline, I'm talking about, rather than, I know you wouldn't have any role in their legal case.
There would be prisoners who would complain that their treatment for an infraction was unfair.
Yes.
And we would discuss the prisoner's view, and sometimes that could be reversed or inquired into. But what's really crucial is that when we go back to the prisoner, they are extremely appreciative that somebody listened and actually took a step to exercise the system that was prevailing within the prison.
So you have had cases where they're overturned, where the breach or the complaint which was imposed by the governor was overturned. Have you had that?
Occasionally, yes. Okay. But as a visiting committee, we don't exercise any direct or indirect role in the management of discipline.
Okay, thanks.
But if it converts into a complaint, yes, we would. If it was a very serious complaint, well, then it would be referred to the inspector.
Okay, just in relation to any of the other questions.
I think I'll let it happen from there, Secretary. It's probably more efficient. Thank you, Deputy Daly, for the explicit question. Yes, we do welcome the future role of the office in relation to monitoring detention in Garda stations. For people who end up in prison, very often their detention journey has been a continuum from the moment when they're arrested in the street, transported to a Garda station, taken to court, placed in a court holding cell, put in a prison van and taken to prison. It's a continuum. I think as someone who has spent the best part of the last 30 years monitoring both police and prison detention, it's extremely important to be able to monitor the protection of rights at every point in that continuum. To give you a practical example, when we interview people in private in remand prisons, that's a very good opportunity to gather detailed information about what their experience has been in Garda Síochána stations. And it makes sense that I will also, with my inspectors and senior inspectors, have the potential to follow that up. We will be looking at issues including the protection of procedural rights in Garda custody, and chief amongst those, access to legal advice and effective access to legal advice. This country currently has one of the lowest rates in the European Union of effective access to solicitors in police custody. And I'm keen to look at what are the underlying reasons for that. The safeguard is there in law. The possibility for solicitors to be present in Garda stations is there in practice, but the take-up rate is very low, which means that the potential prophylactic impact of that procedural rights protection is not being maximised. And just finally, to pick up on a point that you made, and also Mr. Herrick from the ICCL made, it's crucially important that what we do in future as the Office of the Inspectorate of Places of Detention dovetails effectively with other accountability mechanisms in the policing area. So we're already laying the groundwork for that. I'm consulting with the current policing authority. I'm consulting with GSOC. I'm consulting with Garda Síochána. So what we're trying to make sure that we do is we design a future accountability and monitoring mechanism which is complementary to those existing and future mechanisms with policing.
Can I just come back to you and just, I don't know whether Mr. Herrick might have a view on this as well, that there was a heads of bill which came before the Justice Committee a few months ago now, and in relation to treatment of prisoners in custody, and there was a section in it which would give the power to a Garda inspector to remove solicitors from the Garda station if the inspector felt that they were obstructive to the investigation and interrogation that was going on. And this, I think, followed from discussions between the Department of Justice and I think it was the AGSI, I'm not sure, but members of Garda Síochána in any event. Do you have any view in relation to that, or were you familiar with that?
I'm not familiar with that specific provision, so I'd have to look at it in more detail. But in a more general sense, that certainly has the potential to impinge upon the independence of solicitors providing legal advice. It would have to be viewed with great caution. Not all solicitors, of course, are angels, and there has to be some possibility for senior officers to express a view on certain forms of conduct, but of course that must respect the fundamental requirement of the independence of the lawyer.
Thank you, and thanks everyone for your presentations. I suppose there's not anything I don't agree with across any of them. If anything, it's just further emphasising them. But what I would like to do, because it is PLS and the department is here in an observer's role, just to ensure, I suppose, that those key messages are made very clear in any sort of report that we send from here. I've kind of just tried to capture maybe the common themes throughout them, and I'd like to just maybe put them on the record, and if anyone disagrees with my understanding of what's come across all the ones, just so then the message is clear to the observers here in terms of going back as to what needs to actually be addressed within the heads of bill. So in looking at it, I was looking at head 8 and 6, which is supported by the IPRT, IREC, Dr. Gary. It comes up across all of them. So the bill does not ensure financial and operational independence of the IPD and of the MPMs, including separate financial resources and staff, and that would be unnecessary. And if anyone disagrees with the capturing of these, just, please do come in. Need for adequate resources to support the development and infrastructure of the IPDs and the MPMs. The IPD and the MPM should be accountable to the Oireachtas and not the Department of Justice, is what I'm understanding from most of the contributions. And currently the Minister for Justice has a role in appointing staff to the IPD, which obviously interferes with the role of any sort of independence. And I might come back to that staff piece at the end with an actual question in relation to the expertise of staff that's needed. Other stuff I've picked up on is the conflict that the Chief Inspector is located within the Department of Justice budget, which is an issue as well. And then the need for further clarification of the powers within the heads, the obligations within the heads, the expertise and resources of the IPDs. It's also missing the legal basis of and the privileges granted to the NMP's resources, roles and responsibilities, and maybe somebody might want to comment on that specifically. Relation to the functions of the Chief Inspector in relation to Head A. The legal minimum duration should be stipulated, is what I'm understanding, in relation to which prisons should receive an inspection. The Chief Inspector should be empowered to engage with external experts who could support inspections carried out by the IPD, and investigative reports into a serious adverse event or death should be laid before the Oireachtas. And then I suppose the bill, as I understand it, or the heads of the bill doesn't clarify how detainees' voices would be heard during these investigations. So they're just some. There's lots that I have, but I just really wanted to pick up on some of the key points so it doesn't get lost in the wider conversation around reform and prisons and sentences and all that type of stuff, but actually just to focus in on the heads of bill and what's needed in it. Okay. Yeah, so, but one question I do have, and it's more from my own understanding, and what Mark Kelly said in relation to that continuum of detention, and I suppose I'm probably prone to getting a little bit philosophical sometimes, in that poverty is also a place of detention, so that somehow starts even a little bit earlier. And what I'm wondering is, in relation to be able to investigate, and you have a bare minimum, I suppose, of human rights. You have the basic human rights, free from inhumane torture, all that kind of stuff, right? But does that begin to vary to a degree depending on what the needs of the person is who ends up in prison? So if we look at the ageing population, if we look at undiagnosed, and there's more and more prevalence of it now in relation to autism, ADHD, dyspraxia, you've all these different combinations of things that interact with people's becoming actually engaged in the criminal justice situation in the first place, but it wouldn't ordinarily be captured. And I'm wondering then, to tie it back into that idea of what type of expertise would be needed in relation to inspections, because we have to look at the whole needs of the individual rather than just the infrastructure and the basic stuff that somebody might be looking for in an inspector. So I'd love if the questions, it's usually better for me to aim my questions, but it's not aimed, because I really do think that any person here could actually probably contribute equally on each of the things that I've raised. So that question around, do we look at inspection differently when we look at the needs of the individual within the larger system of the prison? And I just love maybe some conversation on that. And if anyone disagrees with my further points, I just want to make sure they get into the report in terms of recommending the changes. Thanks very much.
I might pick up on one of those at the end, just a query, but do you want to go IPRT first, Senator Wren?
Yeah.
Thank you very much, and I think we agree with all of those points, and in particular the privileges and immunities. It's set out in Article 35 of OPCAT, and it talks about things, privileges from, arrest, seizure, that kind of thing, and that's not reflected currently in the bill, which is a pretty important thing to include. Just picking up on the point, Senator, that you made in respect of the expertise, it's a really good point, and actually a really nuanced point that's been made. We in our submission talked a lot about the need for the MPM and particularly the Inspectorate of Places of Detention to be able to draw on expertise and have an expert panel perhaps, or some kind of arrangement where they can draw on expertise as needed, and perhaps in particular in relation to a specific visit to a specific prison. But more generally in that kind of expertise point, I think it's actually really useful to think about expertise in a broader sense, and really thinking about those individual needs, so the kind of medical, the mental health aspect. But Senator, you've identified quite a few different things, and I think actually that could be really useful. Obviously, it may not be possible to put in all of that within a piece of legislation, but certainly putting in that place of the role of experts is going to be really important, and that's very much emphasised by all of the international guidance on this. So I think it's something that needs to be reflected in the bill.
Perhaps Mr. Herrick, Dr. Garrahy, if they haven't had the opportunity, as you wish.
With regard to the question about special needs and particular needs, I mean, I suppose we're particularly concerned about the prison, the police detention aspect as much as the prison detention aspect, and we're particularly taken by, I suppose, the recent report on custody that was produced by the Garda Inspectorate, which I think addressed many of the issues that you raise, the particular needs of particular groups, and also the very high level of detention in police custody of people that are there for mental health reasons in the broad sense. So I think it does emphasise the point that's been made earlier about this continuum of detention. And it does, I suppose, get to the very heart of what the philosophy behind this international treaty is, that it covers all places where people are detained, all closed spaces where people need special protection. And I suppose at a broad level, that's the difficulty we have with the approach that's taken in this bill. The approach is quite narrow. It's about prisons plus police detention, and whereas there is an intention to include a wider range of sectors, including mental health and so on, there's very little detail at the moment. Now, of course, the opportunity is there for government to specify much more detail as we progress, but there's no stated intention to cover many of the types of facilities that we think should be encompassed here, such as nursing homes, care homes and others as well, which are in what you might call a category of quasi-detention, and we'd include direct provision in that as well. So I think you're absolutely right, and legal distinctions between different legal categories of detention don't fully capture the fact that many people would experience a variety of different types of institutional care at different stages in their life.
Senator, is there anyone else you wanted to ask? I think Dr. Garrahy, if you don't mind, because we haven't heard from Dr. Garrahy at all. No. Sorry, just seeing waving. I'll come back to
Thanks
Mr.
very much.
Yeah.
Just very briefly, I won't go down the philosophical route too much, but I think it does raise the question, if we look at the demographics and needs of people in our prisons, including mental health, poverty, education, deprivation and so on, it begs the fundamental question whether we should be sending them to prison in the first place. That being said, when we look at inspection, one thing that hasn't, I think, been mentioned so far, but is in many submissions, is that what expertise is needed, people with lived experience of the criminal justice system is needed. I think that's a glaring omission in current procedures. And then, finally, some of the issues that you absolutely summarised very well is are answered by OPCAT itself. You know, so ratifying it addresses and adhering to it addresses many of these questions about independence, about resources and appointments and so on and so forth.
Thank you. Okay, well.
Just to respond to a couple of the specifics that Senator Rowan raised. Firstly, thank you very much for the summation of the consensus around independence. Just to highlight, also on that list, I think I would have head 6, subhead 2, which specifically proposes that the future funds of my office, premises, facilities and services would all be provided by the Minister for Justice. So it's quite detailed and it's quite prescriptive. Senator, you asked about the question of protections and exemptions, privileges, and what explicitly that would mean. Flowing from the OPCAT, there is a concern to make sure that people who are doing this monitoring function are themselves properly protected, but also highly sensitive information that we might be gathering is properly protected as well. For example, if we are involved in the investigation of deaths in custody, we might have hugely sensitive information. We always have sensitive information around the reason, for example, why someone is in prison in the first place. So the protections, we think, should include immunity from search and seizure of documents, baggage and so on. It certainly should not be the case when I enter a prison or Dr. O'Connell enters a prison that it's possible for a prison officer to require to inspect papers that we have with us, either going in or going out. And in our submission, we give some more detail on that. Lastly, on the question of vulnerability, absolutely. Mr. Herrick referred to the Garda Inspectorate report on custody, which is very good. It's based on the standards developed by the European Committee for the Prevention of Torture, or CPT, for which I've been working in one capacity or another for the best part of 3 decades now. And in recent years, what we've been doing in the CPT is looking at the need to take a trauma-informed approach to monitoring, particularly in prisons, and explicitly to take into account trauma that may have been experienced by people before they come into prison. So when I said I was in the new prison in Limerick, the new empty building, I should also have said that I was in E-Wing, and I spent time there with the women who are currently detained in very poor conditions in E-Wing. And it's very obvious in Limerick prison, as it is in prisons holding women throughout the Council of Europe space, that many of those people who have ended up in prison have a whole history in which they've been victims themselves of domestic violence and other forms of trauma. And they carry that with them when they come into prison, and they can't just be treated in an identical way. And so in our monitoring, we will be bringing with us people who have explicit expertise. We will be bringing with us psychologists and medical doctors.
I might come back to Dr. O'Connell on a later point in relation to trauma, if that's okay, but I think now Deputy Pringle, please.
I wasn't expecting me to be next.
I'm sorry.
Yeah, sorry, sorry I missed the introduction, your opening talks, and some of these questions might have been dealt with, and it's probably what I would be just as it will be a rehash over what you've said as well. But I think it's important, just in relation to the accountability to the Oireachtas rather than to the Department of Justice and that there. I wonder, would you have anybody have any examples of why that's important? Maybe first-hand examples of why that's important, because I think it is very important. And how, if it was accountable to the Oireachtas, can it still be that the budget would be provided by Justice, and would that make a difference as well to how the operation of the system would be in the future? And again, I suppose the financial independence as well of the inspector would be important too. And I'm just wondering if, say for example, we were made independent and accountable to the Oireachtas, would that be enough without all the other stuff been sorted out as well too. I'm just wondering what the minimum level would be required. And in relation just to Head 14 and the places of detention issue and the inspection of those, direct provision I think is one that would be very important. But I mean, the hospitals and stuff like that and nursing homes would already be inspected by HECWA and stuff like that there as well. I wonder, is there a need for a duplication, or would that be important? I just wondered if you'd expand on that a wee bit as well too, please. And also on the need for direct provision to be included in that, and maybe how that could be classed. Maybe the definition of terms of places of detention might not be appropriate for that as well too. Thanks.
Thank you, Deputy. Who would you like to start?
Anybody at all.
Thank you, Chairperson. Thank you, Deputy Crew. My colleague Sean Beattie might address this question of the broader categories of detention.
Thanks for that question. We refer to Article 4 of OPCAT, which says that it defines places of detention as any place where persons are or may be deprived of their liberty. And in interpreting that, if I could quote, it's a very short quote and it's very material to this, from the Subcommittee on the Prevention of Torture, and in their annual report in 2013, they said the term places of detention should be given a broad interpretation to include, among other things, civil and military prisons, police stations, pretrial detention centres, and then psychiatric institutions and mental health centres, migrant detention centres, juvenile detention centres, and social care institutions. And then it goes on. Therefore, an interpretation of places of detention that is limited to such traditional places of deprivation of liberty as prisons would be overly restrictive and, in the view of the subcommittee, clearly contrary to the optional protocol. So we say it's crucial that the committee does consider those non-traditional places of detention and considers whether factually liberty is being deprived. And we say, as currently constructed, the general scheme of the bill would be clearly contrary to OPCAT.
Could I ask Ms. Keane as well from the Mental Health Commission? Does it relate to place of detention also?
It's just interesting because we've really, Deputy, had a discussion with the Department of Health in relation to the legislation on deprivation of liberty. And I suppose perhaps those concerns in relation to people in nursing homes and such facilities might be differentiated to those in involuntarily detained improved centres or otherwise, and dealt with under that legislation. Just to say, the Commission hasn't particularly thought about that particular issue, but it's just an observation that I suppose we would agree that while firstly, I would agree with my colleague that it shouldn't be limited just to prisons. And I think I should also, if I can take the opportunity here to say the issue about Garda stations would be very important to the Mental Health Commission. We have been in recent discussions with the Gardaí, and I have to say very helpful discussions with them about how their staff are operating certain sections of the Mental Health Act, because the Commission doesn't believe people that are suspected of having a mental disorder should be going into Garda stations. But if they are going to continue to go in there, we would welcome that somebody has an oversight of them going in. But it's not an appropriate place. So we would welcome oversight in relation to the Garda stations, but in relation to nursing homes, perhaps that category could be distinguished and might be better dealt with under the forthcoming it was originally deprivation of liberty safeguards, but they have very kindly changed it to protection of liberty safeguards, which I think is more appropriate. But that will be our view on it. Thank you.
Thank you very much. I might bring in Dr. Conroy and Ms. Brady about a minute each, if that's okay.
Yeah, I think there is a worry about an imprecision as to what is a place of detention. If for example, you take a guard of a van that's moving a prisoner from one place to another, one has an image of something moving through traffic. But actually, that's not always what happens. You can have a van that arrives at an airport or a port and then stops with the prisoners inside. And in law, those prisoners can be detained there for up to 12 hours. Well, myself, I wouldn't fancy being in one of those vans for 12 hours. But secondly, there's a different type of problem, I think, which the Mental Health Commission has referred to, which is when is a detainee a patient, and when are they a detainee? And I have visited very many centres for people with disability where the entire building, contrary to fire regulations, is locked permanently, and any visitor cannot get out. You have to ask permission to leave. And I've also visited many places, centres inside hospitals, which are designated for the treatment of people with severe and enduring mental illness. And unfortunately, those people do not benefit from the prison rules. The prison rules is a standard which, in my opinion, gives to prisoners better conditions than those who are detained in the wards of hospitals. It gives them a right to be out of their environment, gives them a right to fresh air, gives them a right to wear their own clothes. Many, many rights in the prison rules do not apply to patients held in mental health facilities designated for holding persons against their will.
Thank you. Okay. Ms. Brady, did you want to come for a minute?
On a couple of your points there, Deputy. I suppose in terms of accountability to the Oireachtas, we welcome that this bill actually will allow the Chief Inspector to lay their reports before the Houses of the Oireachtas rather than give it to the Minister for Justice, because as Deputy Daly pointed out earlier, we've seen that with the DOCUS reports where they still remain unpublished, and that is because of legal advice to the Minister. So we would welcome that, but we also think the perception of independence is extremely important. And if you look at other bodies like IREC, like the Ombudsman for Children, they all report directly to the Oireachtas rather than the department itself. And I think that is extremely important. In terms of the duplication point, we would see that HICWA should be designated as an NPM in its own right. It inspects Oberstown, as well as all those other things that you mentioned, and I think that is crucial, and we would hope that this committee would have HICWA and IREC in before it as well, because I think they are key to this functioning well. So I think that those are some of the points you know, that other colleagues have touched on the other pieces. Oh, on the budget piece, just one thing I would say, I think it's extremely important. Part of the reason for it to be independent is that at the moment justice agencies have to ask the Department of Justice for permission if they are spending over 25,000 in terms of IT. You know, that can delay things. If you're trying to get a body up and running, I think, you know, we've seen that with the parole board, for example. I think, you know, there needs to be that independence, there needs to be that freedom to allocate resources as you see fit within the body. So that's what I would say in the budget.
Brady. Deputy Costello.
Thank you very much, Chair. There has been a lot of talk about the independence and the essential need for independence, and I would agree with that and underline that. Senator McDougall said about the possibility of the inspector being neutered, and I think we've seen that already, as Deputy Daly said in relation to the reports just mentioned. And just to be clear, it is 3 reports on the DOCA Centre. A 3-day monitoring report from August 21, a Section 31(2) investigation from February 22, and a supplementary report to that from July 22, none of which have been published, you know, which raises very serious concerns and very serious questions. So anything that, I think we need to underline the essential nature of the independence, the essential nature of transparency in all of this, and those reforms are very much to be welcomed. Deputy Pringle has preempted some of my questions in relation to HICWA, and I would totally agree with the point Ms Brady made there about HICWA needing to be designated as an NPM, partly because of Oberstown, yes, and Trinity House and the Oberstown campus, but also secure care facilities, Ballydowd, Cuva House, Crannog Nua. These are places where young people are detained by order of the High Court. And, you know, HICWA currently inspects them, so it's absolutely essential. And I was hoping to get a bit of clarity from Ms Keane in relation to the current role of HICWA and just how HICWA and yourself work, because that's just, I'm unclear on that, so just for my own education. And then one other question, both the IPRT mentioned the Australian situation, and Mr Garahy, in your studies as well, just comparisons with other countries that have ratified OPCAT is there something that we are missing in this legislation that other countries have done that we should be learning from, so we don't have to reinvent the wheel? And I guess just one final point then, I would underline the point by the ICCL and others around the definition, because for me it is essential that places like Ballydowd and Cranaghnua and Cuva, these secure care units, are included in this, because we are dealing with, there have been serious questions over these places in the past. I know, perhaps this is my Children's Committee hat sneaking in. There have been serious questions over these places in the past, and, this is where young people are detained by an order of the court. So really, it's absolutely essential they're included.
We might take the IPRT and Ms. Keane specifically mentioned.
I can just come in briefly on the point around civil society engagement, and just to say, the importance of civil society engagement is that civil society can kind of provide information to an MPM in its relevant area. It can promote awareness among the people because it may have already built up trust with certain detainees, and it also can provide a role in kind of ensuring external accountability and scrutiny to the MPMs once appointed. I think in terms of what the legislation could do, I had a quick check. There is no mention of civil society and non-governmental organisations in the bill as it currently is drafted, and I think there's a bit of a discussion and thinking around exactly how that should be framed. Looking at international models, some take the approach of civil societies actually being in the MPM. I don't think that's the approach that we would necessarily suggest. More so, civil society providing an advisory kind of capacity. And in Australia, as you mentioned, and as was mentioned in our opening statement, the Australian MPM coordinator has been considering and planning to establish a kind of civil society steering group or advisory group that could help inform. So I think in terms of the bill though specifically, I don't think you need to go into the full detail of all of that, but I think it's about actually recognising that. It is something that the SPT in particular has recognised the importance of, and I think there needs to be at least some mention so that there is some kind of basis for that to actually happen in the future. And IREC as the MPM coordinator already has a role engaging with civil society, so there's kind of an already, a model there in that respect.
In relation to the Commission's relationship with HICWA, it's a good one. We last year published joint standards in relation to children. There is an MOU between them. So, for example, this particularly arises in relation to community facilities. You might have a community facility that HICWA will identify, well, actually most of the people here are here because of mental health issues, and it should probably come within the remit of the Commission, and vice versa. So there's a very good relationship in that, in trying to identify, and then if there is a facility that should be looked after by the Mental Health Commission, then the Mental Health Commission can look at what are the appropriate resources and vice versa. And that is important. I should add earlier my comment in relation to the protection of liberty safeguards was very much limited to nursing homes. Obviously, if there is any facility where people are detained on an order for the court, those facilities, I believe, should come within this legislation. As you know, our inspector is currently carrying out a report in relation to CAM services. There are a certain limited amount of children detained under the Mental Health Act, and a lot of those then might cross-refer to children detained under the childcare legislation. But again, it's very important that there should be more oversight, and that's something that we have sought in the amendment to the Mental Health Act, more oversight and input in relation to the area of children, because the inspector's role is very limited. Finally, I should say that the inspector's powers under the Mental Health Act are in fact quite broad, and probably slightly broader than HICWA's, but interestingly, they're both regulatory regimes that under legislation, which are not very far apart in terms of years, but they're quite, they have quite a lot of differences in terms of regulatory regime. Whether that's a good thing or a bad thing, we'll make no comment, but it is surprising about the lack of similarity between the two regimes. And I think that is a lesson. Maybe I pointed out here in our submission that, even in terms of the reference to treatment and those type of things, each of the different pieces of legislation all define these terms differently. So what is the term that is going to be applied and what is going to be used? So there is, in our view, quite a bit more homework to be done before this scheme can become a bill, because they are practical issues that are going to be faced by people on a day-to-day basis. Sorry, I went on a bit further.
No, it's very helpful, thank you.
Thank you. Is that okay, Deputy Costello?
Yeah, and I just, Mr.
Yeah.
Gary, I think.
Thank
Thanks very much, and I'll just be brief, but I think sometimes when we compare between jurisdictions, it's better to learn from what they did wrong than what they did right. And New Zealand is an early adopter of OPCAT, and some information is coming out of there, and some of them are things we've raised today, such as being already compromised by resourcing arrangements, such as lack of independence, and also their inspection capacity being constrained because of the resources available. So they can only do so many inspections because they don't have the resources to do more. An issue I mentioned already, having no people with lived experience of the criminal justice system involved. And then also, interestingly, in New Zealand, they have a prison ombudsman who is the MPMM for prisons and does inspections and so on. But I note that the bill lacks any dealing with complaints mechanisms in prisons, and whether the new revised complaints system, what that will look like, but whether a prison ombudsman should be established in Ireland is a key point that needs to be addressed as well. Sorry, can I make one point? Just to say that if OPCAT is ratified immediately, there is a period of 2 to 3 years, but in that time, the expertise of the SPT or the Subcommittee on Prevention of Torture can be availed of. So again, we can use that resource to iron out many of these details.
Okay. Members, are there any other members signalling on round 1? Deputy Farrell, Deputy Smith. I'll go to round 2. So I've Deputy Daly followed by Senator Rowan.
Just for Professor Garrity there in relation to, you mentioned the prison ombudsman. What's your view in relation to that? For what level of complaint should it address? And just while I have you, in relation to the, you studied the comparatively Australia and New Zealand, and on their prison visits committee, what qualifications, do the people there have a background in, having been in the prison, dealt with police or prisons or some sort of inspection in their professional career before going into this type of work?
If I could deal with that one first, I think that it's important not to turn inspection bodies or any form of NPM into a body of experts only, if that makes sense. And again, how we define expertise is quite broad. So I think that having a diverse representation on rather than putting restrictions upon entry. But I think the other way around could be to make it clear that people without expertise, lay people, for want of a better word, or people with lived experience, are welcome to join these committees, and therefore the combination of expertise is much more fruitful and beneficial to the inspection and outcomes. But also, I think certain resources require expertise in administrative capacities, such as report writing, such as interviewing or dialogues with people. Interviewing maybe is not the right word for inspection mechanisms. And so I think that we need to be very careful to gather a wide range of representation, but not fall into the trap of narrowing that by having a prescriptive list of expertise needed. Because again, what can happen, just to speak about the literature on this, is that people with experience working in the criminal justice system become the default option, and then you get people who are retired police officers, prison officers, and that's not an ideal situation. Not that they're not welcome, but again, it can be a pitfall. On the second point, I think
in Australia and New Zealand, who is on those committees, and what's the
there is a variety. They don't have a set criteria for only those expertise, but there are expertise in terms of psychologists, in terms of people with legal backgrounds and so on. So it's, I wouldn't say it's the model we should just look at and take, but there is a greater variety than
is there public appointments?
I believe there is. I'm not 100% sure, okay. Sorry, I believe there is. I think the public appointments part of this is key, but I think that as that's in the bill, that's accepted at this point. In terms of the Ombudsman, I think that the complaints procedures are under review at the moment, so it's hard to know what
that is going to look like. However, the current form of having 5 or 6 categories of complaints is very cumbersome and problematic, especially for people who are in prison and don't have the resources and often the information about complaints and how to do that, not least people with English as a second language or reduced capacity in English. But in terms of what an ombudsman should take on, I think that a level of what would be called Category A or B in the Irish Prison Service now, which is very serious complaints around violence, discrimination, abuse of rights and so on, would be the first port of call. But I think that how the other complaints are dealt with is as important as deciding what the prison ombudsman would deal with, if that makes sense.
Yep. Do you think that there should be a prison ombudsman, yes, a separate, or do you think it should be under the regular ombudsman's office?
I think it should be a separate one. I think complaints has been a massive issue in Irish prisons for generations now, and I think to deal with it effectively, it should be a designated body. And also, I think that if we look at OPCAT and NPMs in OPCAT, they are not supposed to do inspection or investigations. That's not supposed to be an NPM's role. So therefore, an ombudsman would burden some of that workload as well.
Okay, and just for the prison visiting, have you had complaints as to how the complaints before, which are dealt with by the governor, have been dealt with inside in the jails?
We very much welcome the fact that the complaint system has been updated. There's no doubt about it that that's long overdue.
And are the prisoners complaining to you about it?
Well, there would be some complaints, yes, but as we said earlier, serious complaints would always be Category A. There would be either Category A, B, C, D and E at the moment. Category A would always go outside to, it's a legal matter outside the scope of the prison.
And are the governors happy with the way that the system is working at the moment, in your experience?
It can always be improved on. There's no doubt about it that we would welcome an improvement, and the changes that are taking place, and training for staff as well to go with it.
And an ombudsman, prison ombudsman, have you a view on that?
Yes, that would be, yeah, we would be in favour of that.
A separate prison ombudsman?
Dr. O'Connell?
Both of you, yes. No.
There are quite a lot of serious complaints, that would have to be looked at in a completely separate way.
We're just at the end of that time, but this is a point I want to come back to, is that interaction.
There is a problem at present, which is that the severity of the complaint is decided by the Irish Prison Service. So in that sense, they're policing themselves. And that categorisation of complaint, say assault against another prisoner, or gross racism vis-a-vis another prisoner, very serious complaints should not, the category of the complaint should not be determined inside the system from which it emanates. The category should be decided independently, for example, by the Office of the Inspector.
Dr. O'Connell?
I'll just briefly add to, so we in our current role have oversight of complaints, and we can investigate circumstances around complaints, but we do not investigate complaints. We noted in our written statement that we see that there is no role for the OIPD, we're referring to the OIPD, in the complaints mechanism. But if you look at our annual reports for the last 3, 4, 5 years, we've been saying this system is unfit for purpose, and for many of the same reasons that you're saying. And the IPS themselves will tell you that there's just a backlog of complaints. Getting them investigated is an issue that we have seen long, long delays. So we would want to take this opportunity to also call for a prison ombudsman that would be looking at complaints so that they're not, as you said, being categorized and investigated. Well, they're independently investigated, but categorized by the governor. And after an independent investigator reaches a determination, the governor does have the power to overturn the decision. So it's a bit messy. So I think it's definitely worth looking at.
Senator Iran?
Thank you. I suppose this one's just a yes/no answer, but would the ombudsman then take over the investigation role and leave the inspection role to the inspector?
Yeah. Go ahead.
Well, just to be clear, Senator Iran, we don't currently investigate complaints. We have what looks like an oversight role, but in fact, all it really means is that we are informed of the more serious complaints. And it's a huge frustration for me and for my staff that at the moment, there's really nothing meaningful that can be done when we receive that information. But processing complaints and inspection are two completely different functions, and it's not a good idea to
have them
commingle
together.
them. So that's why we think that there should be an independent entity, either a freestanding prisons ombudsman or
a role within the inspector.
role within the ombudsman's office.
And then just in relation to inspection centres, because we talk about a lot of prisoner on prisoner stuff, but what comes up very little is actually the staff on prisoner stuff. So in relation to the prison guards, so I mean, when I would bring up the complaint system within the prison system, a lot of the prisoners or a lot of the lads within prison would turn around and they would say, no. So I'm surprised there's a backlog, because if actually they were empowered to make actual complaints, I can't imagine what that backlog would actually look like, because there's a culture also of there's no point in making complaints. There's also a culture of fear to make a complaint in relation to a person's progression. So a man may feel with the dynamic between him and particular prison guards that prison guard actually can get in the way and act as an obstacle to an individual's progression if they start to raise issue in relation to their treatment, in relation to bullying, in relation to goading prisoners. I mean, the dynamic there, what type of oversight actually exists currently in terms of the conduct? Outside of the structures of the IPS, is there a role for the inspector in terms of the conduct of the prison guards? And I know, like, rightly so, they're very heavily unionised, but the union is quite strong there. So sometimes when you actually come in to actually look at the role of the prison guards, they seem to be a protected bunch within that system in terms of never really being aggressively kind of looked at in terms of their role in human rights abuses within the prison system.
Yes, I think that's an absolutely valid observation. Even with the very limited data that we have at the moment, which is oversight of the category AA complaints, there are certain patterns that are observable, and there are names of certain prison officers, for example, that occur with a certain frequency. I've only been Chief Inspector for 2 months, but one of my next top priorities is to work with what we currently have to see what more can be done to effectively engage with the fact that that pattern seems to be there. And actually, I'm meeting Karen McCaffrey, the Director General of the IPS, tomorrow to discuss that, among other matters. So you're absolutely right, Senator Ruan, to highlight that.
Brilliant, thank you.
Dr. Garrahy, please. Yeah.
Very, very briefly, I think that's an issue that doesn't get enough attention at all. As someone who spent 4 years researching prison officers in Ireland, I think, and I said this when the framework for the Office of the Inspector of Prisons was being drawn up a number of years ago, we get a lot of statistics on assaults with people in prison, on each other, on staff, but there's never any statistics on staff assaults on people in prison. Also, in terms of oversight, there's very little, and in terms of sanctions, there's very little. The default option appears to be to delay increments and hit people in the pocket, as officers would call it. And I think that this is something that needs to be addressed, but also needs to be laid out in terms of annual reports and so on and so forth. What disciplinary matters have been taken, and that's not just for abuse of prisoners, it's people in prison, apologies, it's people who are sanctioned for being drunk on duty, people who are sanctioned for being late, absent for months on end, all these things that don't get any public scrutiny whatsoever.
Could I ask the prison visiting committees just their view on this, please, as well? Well, yeah, no, just on the point more broadly, but in part in the prison, what I want to try and capture is just your experience on day-to-day visiting, because I suspect you have a number of different prison visiting committees around the country feeding into yourselves and you're representing them, and I'm just conscious of I think anybody watching, you know what I mean, would benefit from the opportunity to hear from you about when you go, what you do, what you see. Just if you could explain, that for the committee, because I think that, you know, we've covered a number of different measures here within prisons and questions around violence and that. But just can you explain from your perspective, please?
Thank you. I think one of the pieces of information perhaps missing from the bill is what would be the standard used to measure and inspect and monitor a scenario or a situation. For us, it's clear we're using the prison rules, which is a statutory instrument, and the prison rules guide you as to what to look for, and even to ask prisoners whether they are aware of their entitlements to certain information or to special diets or particular clothes or the reasons for the stopping of a visit from a member of the family. And most of what the prisoners ask for is very, very small. They ask for so little.
Can you give us like a couple of examples, the kinds of things, phone calls?
They are concerned that they have their tracksuits and their matching sneakers, that they are, if they're lost, they seriously want them back. They ask for very little. It's only occasionally that they would ask for more serious topics like opportunities for workshops, time out of their cell, or opportunities for the whole family to visit them, which isn't possible at the moment because the prison rules have, the most important ones, have been suspended since July 2020. And the suspension of the prison rules means that neither the prisoners nor the governor have the right to offer to prisoners the opportunities to which they're entitled. And this is visible quickly to visiting committee members. And sometimes the governor will actually signal there are issues with A, B, C, and D, and we'd like you to look into them. Or a prison officer would say, I'm worried about prisoner X, would you mind calling by and see where he's at? Now, we're not social workers, but we can give a report on whether that prisoner needs extra attention, or maybe shouldn't be in the prison at all. Maybe he should be in the Central Mental Hospital with severe difficulty that can't be resolved inside the prison. He can't receive the medication in a prison that he would be given in the Central Mental Hospital. So those prisoners remain hallucinating often, unable to communicate. Their speech is impaired. They can barely tell you what's wrong with them, and yet they are within the prison. And I think it's meeting those prisoners. You know what the job of a prison visiting committee is, which is to signal they should not be there and they must have special attention. So I think the idea of this bill under which prison visiting members would not be paid, would not have their reports published, and would not visit too often is quite unacceptable.
I wanted, if I may, members, just to ask that, just to tease out that issue between the role of the prison visiting committees vis-a-vis the other structure and how that could and should work. It seems to me like, and I visited Clover Hill with Ms. Ryan there a little while ago, and I visited Limerick, albeit without the prison visiting committee. And the communication between the governor, the people who are in prison, the staff, some of the issues that you're describing there, Dr. Conroy, are, you know, where somebody has a mental illness which sort of kicks off in some way, can become a very difficult issue to manage from a staff perspective, you know, in lots of different ways. And what I'm saying is that the role of the prison visiting committees, to me, it seems to be a sort of a nuanced in the centre somewhere that provides good communication tool across the different structures of the prison. And it's very hard to capture that sometimes in legislation. It's very hard to capture that. So what I wanted to ask maybe the IPRT, yourselves, Dr. Collins, Mr. Kelly, and yourselves, is just how should that interaction work best so that we don't lose something within a new structure that actually captures something very nuanced in a very difficult environment, albeit updating and improving the structures overall. Ms. Ryan, you have your hand.
That a lot of people don't know anything about the visiting committee and assume a lot of stuff, like that we're volunteers or that it's sort of a do-gooders thing, where the visiting committee is a very unique and distinctive and effective vehicle to monitor. And an awful lot of what the visiting committee does depend very much on its independence. We have to retain that independence, which is what we will be talking about in the other part of the bill. And it's vital that independence is kept, because it's that independence that allows us to actually go around and go in any time, anywhere, in any area of the prison. And we can walk in, we're there weekly, fortnightly, monthly, or if it's needed. We go for celebrations, we go to the workshops, we can go to visit the kitchens, we can visit all the important parts. An awful lot of bodies don't just have the time or have the opportunity to see them as frequently as we do. And then we build up that trust. And the trust is built up from time and experience of going in, and also because we couldn't function properly, or I shouldn't say we shouldn't function properly, but we function very well because we have built up trust with the governor and with the senior staff and with the ACOs and perhaps with the chiefs. And we're known around the prison, and we have a very good relationship, and that is very important, because what we mainly do is listen. We listen, we observe, we have respect, we speak freely, and prisoners will tell you. You ask a prisoner how she or he is doing, they will tell you. I mean, there's absolutely no bother to them. And when they come to see us in the visiting committee, they could come with a whole complex of questions, or they could come with one. It's only through listening and through experience and delving into it, you find out there's actually an awful lot more that they're concerned about. And some of the things, as we said earlier, are simple, like the runners, or you're missing your clothes, or your post, or you haven't spoken to your girlfriend, or you haven't spoken to your partner, or whatever it is. And sometimes there's reasons for they don't want to be on the card, and it's, you know, we've got to be careful with stuff like that. But it's a whole. We walk the lands, we see them face to face, and that is the uniqueness of the visiting committee.
Could I bring in then, say maybe just the IPRT, Joe, or Dr. Gallagher? I'd like to just sort of reconcile this point, because it's obvious we've been left with some space in it in the bill, and the bill, our heads of bill even referenced that there's a review going on, so it's clearly an open question for the department. So we might as well have the conversation now. Mm-hmm.
Yeah, well, that was one of the things I was actually going to mention. You know, the bill was published one week, and then the public consultation prison visiting committees was published the following week. We had to do 2 submissions at the same time, so we were very aware of it. I think really, you know, I suppose, why is there so much detail within this heads of bill on the prison visiting committees when you then have a public consultation? Should that not have informed the direction of that? I think there is a real value in prison visiting committees, but I suppose what we really want to see this legislation do is that reform piece, have consistency across the board, have transparency around them. You know, I've spoken to a number of people who've been appointed to visit prison visiting committees, and just they weren't even aware of what the process was, because there isn't necessarily a very clear appointments process. So I think that's something that really needs to be looked at. Also, we would question whether or not prison visiting committees should be or should fall under the remit of the new Inspectorate of Places of Detention, because I think that will require extra resources, extra expertise. It will be quite resource intensive, and also I think you probably lose something in terms of the independence, you know, when it comes between the two. And then one other thing just on that piece, currently as it is drafted, you know, there will be a composite report for all the prison visiting committee reports that go into the inspectorate. You would lose a lot from that. No prison is the same. You might get some trends, but you would lose kind of the current issues that are coming up within a particular prison.
Yeah, I would agree. And if we could just take the appointments piece as agreed, essentially, because that's dealt with in the bill and we know where that's going. It's what it does, its independence, its interaction. I agree with you about the distillation of points. Dr. Garahy?
Thank you. I think it is a very good question, and it's a very tricky question because, as I mentioned earlier on, prison visiting committees remain one of the only ways that people in custody can bring their concerns to an independent actor. But we can't ignore the prevailing perception of prison visiting committees among people in custody, and you know, people like myself who research prisons, who there's been a sense that PVCs are too close to governors, are too close to IPS, and that independence, which is much vaunted, may not be so apparent in many of the reports, in many of the, you know, in terms of whether something's been overturned or not. So again, you know, and to bring the IPRT point on report writing and report issuing, you know, there's a serious imbalance in the quality of reports from PVCs in different prisons. And it can be very hard to glean much information from a 4-page annual report. So I think there are question marks about the ideal role, as you say, but whether that comes under the remit of, in terms of OPCAT, it can't be an NPM. It doesn't fit the criteria. Placing it under the new inspectorate may seem to remedy that, but I think, as people have mentioned, it's a serious undertaking and requires a root and branch reform in terms of appointments, in terms of expertise and training. And as people mentioned, often people don't know the process of being appointed. They certainly don't know the terms of reference for what exactly their role is. So these are issues that are not insurmountable, but they're not small issues, and I don't think placing them under the new inspectorate is the quick fix to that.
Okay, please.
Thank you. Just to very much agree with that final comment. The value and the role of visiting committees is indisputable. They're listeners, among other things, and they're hearing the voices of prisoners directly, and that has a huge value in and of itself, and they're a community contact for prisoners, and we shouldn't lose that. But if it would help the committee specifically on part 2 of the general scheme, and more specifically on head 13, we addressed this on page 19 of our submission. We have absolutely no aspiration as an inspectorate to be involved in establishing a visiting committee for each prison, nor do we think it's appropriate that the visiting committee should effectively report to the inspectorate. Head 13 subhead 12 could be read as implying that the visiting committees would somehow be accountable to the inspectorate of places of detention. That's not something on which we were ever consulted, and we don't think it's appropriate. We think it would impinge upon their independence. And finally, head 13.13, the idea that somehow our inspectorate would take all of these disparate elements from different visiting committee reports and somehow edit them into one composite report, I think is illusory. The resources that we would have to put into that in terms of liaison with the visiting committees, fact-checking, editing, etc., would be really disproportionate to the quality of the outcome. So as far as our inspectorate is concerned, part 2 of the bill requires extensive revision to capture the essence of the listening and community contact and empathy role of the visiting committees, but without subjecting them to an accountability mechanism, which is not one that is sought by the inspectorate.
Okay, thank you. Senator Ruan.
It's just a quick question. Thanks, Chair, for allowing me back in. It's to the visiting committee. In relation to when you go in, I'm wondering in relation to interpretation and having a good grasp and understanding of any sort of complaints that may come from communities who don't have any English, who often potentially sometimes rely on maybe other people within the prison system that have some English but don't, and then they have to divulge the complaint to somebody else and trust that they're, you know, and that passes it on. And then in a health setting they have to do that as well if there's any issues. So I'm just wondering, is there any need for, I suppose, this committee to look at recommendations around the right to interpretation in relation to human rights, especially with the visiting committees going in or the inspector going in? I was wondering, do you have a good grasp of what the complaints might be from other communities based on any language barriers, or is there a need to actually address that?
I think there's a serious need for a separate translation service that could be established at a central level and runs by telephone into the prisons or even other places within the criminal justice system. And these telephone interpretations work very well. And I've had involvement with them in England, in the borough of Newham. And I think the Irish Prison Service has an obligation to provide confidential and privacy to members who wish to speak, not just to the visiting committee, but they may wish to speak to a chaplain or an emir as well, and that such a service should be available to them. At the moment, other prisoners oblige by offering to translate, but that's actually very wrong, because you should not be disclosing personal information to another prisoner. It's quite wrong. And if the person is, the other prisoner could be of a religion or ethnicity different from the prisoner who doesn't speak English. So I think the translation issue is crucial.
Thank you.
Yeah.
That's a really important issue, because we've seen since the beginning of the tribunal process on the 1st November 2006 to now, the profile of people involuntarily detained, and this will also be the same with prisoners, has dramatically changed. So about a year and a half ago, we have our basic booklets in English and Irish, but they're translated into 8 other languages as well. And so there has to be more documentation translated. Also, we have increased the availability of the translation services. If the inspector goes out and finds people who aren't voluntarily detained, don't have access, they're addressing it with the staff on the day. It's, you know, I cannot imagine being in another country, not able to speak a language and not being able to express yourself and relying on somebody. And the issue about the Ukraine has recently come up, about different people came from different parts of Ukraine. So, and we've had different people from different parts of Africa. So some might speak French, but they're the approved centre will have them written down as A, but in fact they're speaking a different language because they're from a different part of the country. And it is essential, because if you are to give these people a voice, you have to give them a proper voice. Sorry.
Thank you. Dr. Connell? It'll come on. It'll come on.
And just to follow on with that, the Inspector of Prisons, I think that's a hot item that we've been looking at throughout all the we inspected all the prisons last year through the COVID lens. And I can say maybe 5, 6, 7 times we were making recommendations on access to information for foreign nationals and non-English speaking people in prison. Resettlement is also an area that's strongly needed. So when people are waiting, they're talking to IASIO officers trying to get up, there's no way for them to communicate about where they're supposed to go. So I think it's central, and it's become very central to our work. Every inspection now, we give a small booklet to the prisoners to share the findings. It comes in 10 languages. We have information booklets for prisoners in 8 languages. We're starting to survey prisoners using digital tablets, comes in 10 languages. So everything that we're trying to do is try to push to that, because our foreign national population of people in prison is only going to grow. So I think that the recommendations we've been making them, I don't think we can make enough. We should definitely continue to all make that recommendation.
So Dr. O'Connell, you're providing information as part of the Inspector of Prisons in 8 to 10 languages. Are the prisons reciprocating?
The prisons are, so in our recommendation we said on quarantine, when people have been committed during quarantine, foreign nationals have been committed for up to 14 days without any knowledge of where they are or why they're sitting there for 14 days. So in response to our recommendation, they started to provide information on the committal process, how many days, when do you get tested, those types of things. And we've been engaging in kind of a monitoring process on those recommendations. So shortly you'll start to see what the IPS has been doing, and then when we go back in, we assess their monitoring of their own recommendations. So I think there is movement, but there could be much more.
Dr. Garrahy?
If I could just come in on that. Myself and colleagues in Maynooth have just finished 2 pieces of research, one with the IPRT and one with the Irish Council of Prisoners Overseas, on initially minority, ethnic and foreign national prisoners, and then secondly just foreign national prisoners. And this is one of the key findings that came out of it. We spoke to over 100 people of the 560 odd in prison at the moment, and language permeated every aspect of their existence in prison and restrained them in so many ways. But I would note that the IPS has put on record that they are agreeing to translate the prison rules, certainly, and other documents into many different languages. And it's been said at a conference, I don't know if this will happen, but to put out a tender for translation services. As was mentioned, you know, in places like the Netherlands, there is a dedicated phone service. So a governor can pick up a phone, the person can pick up a phone, and there's a translator at the other end. And it's not to say there's no issues with that implementation, but there are things in place. But we also have international obligations here. And prison rules and European prison rules say that people in prison must be furnished with a copy of the prison rules and other documents in a language they understand. The vast majority of people who didn't have a high capacity in English that we spoke to never received any prison rules, not to mention a prison rules in a language they understood. So this, and that translates, no pun intended, that translates further into repatriation applications, complaints we mentioned, all these aspects, the very basic elements of life. So this is, the translation issue is going to be bigger and needs to be addressed.
Thank you. Okay, thank you. Are there any other members wishing to ask questions? No. Deputy Costello.
Just if we could make a very brief point, I think the translation issue is perhaps, as was said earlier, is going to be an issue throughout the justice system, and if the prisoners have found themselves in this position in prison, is struggling against the issues of translation. Their experience of the justice system began in the Garda station and then moved through the courts. What was their experience through? And there's, you know, we've had previous sessions here with people talking about the difficulty of translation in the courts. So I think it's a much broader thing that we as a committee need to look at through from the entire journey of the justice system.
Sure.
I say something that there's a lot of people, a lot of immigrants that come in and people that come in that should not be in prison at all. They haven't been charged with anything. There is no place for them really within the prison system. And that really does need to be addressed at some stage. And of course there are a lot of people in prison who shouldn't be in prison anyway because of mental illness and otherwise. There's a whole wide spectrum that needs to be looked at. One of them is that a lot of people are not suitable at all for prison, and prison is the very last place they should be.
I just wanted to make two observations in relation to some of the things that were said. One in relation to going back to Limerick Prison, and this speaks to some of the issues, whether or not people should be in prison, but some of the issues that go behind it, and I think Dr. O'Connell was wanting to come in on that point. I visited Limerick, the new prison, which is going to open in January, to see what it would be like, and it really is an excellent facility. And chief among the facilities there is a dedicated rape crisis counsellor, which is of huge significance in a women's prison. There are very few people who end up there who don't come from a background of significant trauma, and a dentist, which is also a very significant support for women in prison. We've talked about short sentences, and I agree with all of the points in relation to short sentences. They are absolutely pointless from the perspective of the state, because there is no opportunity to begin education or training programs in any meaningful way. So they don't value it, deliver anything either for the state or indeed for the person in prison. But in particular, the women in prison must be among the most vulnerable, particularly women from the traveller community who haven't been mentioned here today, and I just want to highlight that today. And I think the IPRT published very, very good figures on quite how disproportionate their experience was in being represented in the prison community, and the circumstances in which they had gotten there, and various things that had happened to them to bring them to that. And I'd refer anybody watching to the IPRT figures on that. So I spent 2 hours with women in Limerick Prison having sandwiches and talking about the different issues that they faced, and they are, if I could say, rape crisis centre, dentistry, women from the traveller community, very, very, very difficult circumstances, notwithstanding what else happened in their lives. But I think Dr. O'Connell wanted to come in on the trauma point earlier.
There we go. I was going to mention earlier we also need to consider the staffing of people in women's prisons. So it's the gender-based staffing, it should be a mixed staffing basis, but the high contact points should be run by people who are women. So in areas where you have private interactions, those should be women that are the staff that are running those positions, and that's not currently the part. And also very central, it used to be the case that people who were assigned to work in our women's prisons were trained in gender. I think every prison staff member should be trained in gender because we all have genders, so gender-based violence should be understood across the spectrum. But there is no training in gender sensitivity for prison officers, even when they are moved to work in a women's prison. So I just wanted to flag those key points.
Okay. Notwithstanding that, I would say I thought the Governor was excellent on understanding some of those very different things, and we had a very detailed conversation about what women need and the sort of practical things that women need, down to the sorts of products that they go out of their way to try to buy, to support women in different ways. We might take Joe and Dr. Garrahy and then finish up.
Just two very quick points on the new Women's Limerick Prison. Number one, we talked about new prisons earlier on, but also the opening of this is welcome in some ways, but in other ways it increases the women's prison numbers in Ireland to nearly 200, which is an escalation of imprisonment numbers for women, which is not the direction we should be going. But secondly, just to say that the Doka Centre was state of the art 30 years ago, and I would argue that it's fallen into disrepair and disuse, and many of the things that are much vaunted about this new prison were also present in the Docas and are either not functioning now or have been a state of stasis.
This committee has covered that before, and also acknowledged the fact that the population essentially doubled in there, and it hadn't received the investment that it needed at any stage. But we look forward to this new prison, and the issues about why women are there or shouldn't be there. Mental health issues and other issues are sort of separate to that. But okay, but thank you very much. Okay, so are we happy with that? Do you have that? Pardon me. With the department, although they're here as observers, is there anything that you'd like to clarify for us now?
Happy to try our best. As we were here as observers, we hadn't prepared any speaking notes, but definitely do want to convey a sense that we're very much welcoming the submissions, the comments and questions from the committee. It's very timely, very important to the PLS process as drafting of the bill commences. I had a few points I can make in trying to, I suppose, expand on or explain some of the policy intent behind some of the heads, because a number of questions came up a few times. But just to stress that the general scheme heads are always very scant in detail. That's unfortunately how it works, and it's really setting out the policy provisions. The detail will come in the drafting. Questions around definitions, around clarification on functions, etc. All of that will be teased out with the expertise of the Office of the Attorney General in the course of the drafting process. The report of this PLS will feed into that, and that'll be very timely and important, as I said. The department recognises, of course, that this is much awaited, long awaited legislation. It is government policy not to ratify international instruments unless primary legislation is in place. We have been engaging with the SPT, the subcommittee at the UN, in coordination with Department of Foreign Affairs, and will continue to do so after enactment in a more formal basis and with IREC. A few of the, I suppose, broader questions that came up a few times, maybe just to give some more background to, it is the government's intention that all places of detention will be covered. This bill is specifically looking at the justice sector, but you will see in the heads reference to the Ministers for Health, Defence and Equality, Children. On independence, it came up a lot, and I really want to stress that it is the department's intention that the Office of the Inspector of Prisons will be functionally independent. The obligations are there and set out, and I recognise that we need to make that clearer in drafting. The inspectorate has to report to the Oireachtas, has to have accountability to the Oireachtas, not on policy, because policy accountability is for the government and for the minister. But in terms of the functions and the administration of the inspectorate, the inspector will be accountable to the Oireachtas, and that is clearly set out, and as I say, we probably need to ensure that that's much clearer in the drafting. With respect to resourcing, which also came up a number of times, the previous inspector had commissioned an independent review into the office and the structures and how it would look going forward back in 2018. the recommendation of that review was that the office should stay under the Department of Justice. So that is the basis for that head and for the underlying policy around maintaining the Office of the Inspectorate under the department. Having it separated into a separate vote would cause, in the words of that independent consultant, undue administrative and financial burden on the office, and that any the benefits of remaining in the department outweigh any disbenefits, including perceived independence issues. So again, this was all informing the policy behind those provisions in the heads. The department has sought to increase resources to the office over the last number of years, and there was quite a significant increase from 2020 to last year. Once enacted, the department will continue to negotiate with DEPR to ensure that there are additional increases in resourcing to ensure it can fulfill all functions. Appointments came up at one point. I just want to make that clear. Appointments are through public competition. Appointments are through the Public Appointments Service, not by the Minister. Engaging in civil society, we'll certainly take that on board, and I think that there's definitely room to consider that in the drafting, and then, of course, post-enactment. On the prison complaint system, work is ongoing on drafting secondary legislation that will provide for a whole new prisoner complaint system through the amending of prison rules, and that's being informed by recommendations from a previous inspector of prisons, and that's at quite an advanced stage. And on the PVCs, very interesting, very useful discussion there on the visiting committees. We understand the sequencing was unfortunate. I would just say the bill wasn't published, it was just the general scheme, but the fact that the bill is to be drafted now will be informed by the outcome of a really extensive public consultation and inputs and submissions from the various stakeholders into the prison visiting committees process. So that is also in coming weeks, months, and will inform the drafting of the bill. So I hope that gives some clarifications. We are certainly looking forward to the report from the committee and to seeing how we can take forward recommendations that come from that. Thank you.
Okay, thank you very much, Ms. Doherty. Okay, I propose that we publish all the opening statements on the committee website. Is that agreed? Agreed. Thank you. And now, in conclusion, on behalf of the committee, may I thank you all for attending our meeting today, for your contribution in this important matter and for your engagement and dialogue. We really, really appreciate it. Thank you very much. Can I just ask, is there any other business that any member would like to raise? No? Okay. Well, then the meeting of the Joint Committee is adjourned until Tuesday, the 25th of October 2022 at 3 p.m, when it will meet in public session for a stakeholder engagement on enforcement of court orders relating to maintenance, access and custody. Okay, thank you very much. The meeting is adjourned. Thank you.